to the storage of photographs and fingerprints.
The Honourable Leanne Dalzell.
I feel that that was a somewhat extraordinary contribution from a member that I believe raises the issues from a genuine belief that she has an obligation to raise those matters here, but in the mistaken belief as to the purpose of this particular bill. So I just want to go back to the Police Act 1958, and I want to thank the Minister for explaining the history. I actually thought that would solve the problem for everyone in this House, but obviously not, so I will do it as well. No, not as well as the Minister, but in addition to, not as well, obviously. The clause 57.3 of the Police Act 1958, and I have it here with its nice red lines through it, because of course it's all been overtaken. If the person in respect of whom particulars have been taken under this section is acquitted, the particulars shall be forthwith destroyed, provided that this subsection shall not apply if the person is acquitted on account of his insanity or is discharged under Section 19 of the Criminal Justice Act 1985 or Section 347 of the Crimes Act 1961. Now, correct me if I'm wrong, but that's a discharge without conviction, isn't it? Yes. So we've always had the provision in there that the destruction applies on acquittal unless the acquittal is based on a discharge without conviction, because as the member must know, in order to get a discharge without conviction, the facts have to be admitted. That is the whole basis for the discharge without conviction. It is the only get-out-of-jail-free card that we have in our system. It literally lets you off the hook as long as you admit that's what you did. So I think that it's absolutely plain that the person who wrote that in good faith was basing his or her comments on misinformation from this House rather than the accurate information, which is that we have always allowed the police to retain this identifying particulars for everyone that they collect them off, unless there's been an acquittal, and that hasn't applied if there's been a discharge on the basis of insanity or a discharge, acquittal on the account of insanity or discharge without conviction under the varying provisions of the Criminal Justice Act or the Crimes Act. So those provisions have been there since 1958. If the member felt so strongly about them, if her party felt so strongly about them, why didn't they raise them in the discussion documents that the Minister consulted on? Why weren't they raised in the debate in the House? The truth is that nobody thought that the legislation was doing anything other than reinstating the law as it was at that time. And the only reason that the law has changed or has had this effect is because of some very, very powerfully positive, good legislation for children and young people, which allows judges to make all of these different orders rather than sending them off for sentencing in the district court. And I think that it's really important that the member takes this into account, because all of the things that she says that she wants for our rangatahi and for our young people, she has actually got in the shape of the Children, Young Persons and Their Families Act, with a series of orders that can be made in a youth court, a hierarchy of courts' responses if a charge against a young person is proved. Why are we hearing the member talking about charges that have been laid? The only application of these orders can be made if the charge has been proved. We are talking about children young people rather, who are already off the rails. And I actually accept the Minister's contention in this particular regard, that these hierarchy of responses were actually decided in order to give young people better opportunities, to get them in front of a drug and alcohol rehab service, to get them under supervision, to get different things happening for them so that they didn't have to face the court. And what I'm worried about is that if judges suddenly have to think, well, the court that the police are not going to be allowed to keep information about this young person who's already off the rails. And we actually know that if they've already offended, that they're actually much more likely to be heading down that pathway than not, because we know the reoffending rate amongst young people is so high, Mr. Chairman. And I think that it's really important that there is a clear understanding of why, Mr. Chairman, why we've ended up with this, with these particular options in front of us. But do we want to have a judge actually saying, look, I'm not going to let the police hold on to this. If I make a decision under one of these orders, then I'm not going to be able to allow the police to hold on to that information just in case the young person does reoffend, and it might assist the tracking down of the source of the offending. So I will enter a conviction and order that the young person be brought before a district court for sentence or decision, in which case Sentencing Act 2002 applies, which means that they would be caught by the changes to the Act that member agreed with in 2008. Well, her party agreed with in 2008. So I think we're getting into a circular argument because there is a fundamental misunderstanding that the law always provided for this. The only thing that has changed is that the youth court has got some options for young people that let them off the hook in terms of being sentenced in the district court under the Sentencing Act. And that is a good thing. I think everyone in the House would agree that what the youth court can do today is far superior to what it was able to do in the past. But where the member seems to depart from reality, in my view, is this misunderstanding about what that will mean in practice. Young people who head off down this pathway end up having multiple offences before they turn 18, and then they end up in the adult system, and there is nothing that really we can do to help them once they go over that edge. And anyone that you talk to and rehabilitate, well, I know that there are some, but the Minister will know herself, the cost of rehab when you get into the early 20s is far greater than it is in the teens, as it is far greater in the teens than it is in those very early years. So I think that the whole objective behind this is to make sure that we have the capacity to utilise the legislation as it was always intended to be utilised. And I come back to the point that my colleague Annette King made, and I think it is the most fundamental point here. All of these issues are really important, how we look out for young people, how we do get them onto the right path. All of those issues are really important, but this is not the purpose for this debate. This debate is about ensuring that legislation that was written in 1958, modernised after a series of consultations in 2008, accidentally overlooking the fact that the youth court now had a hierarchy of court's responses if a charge against a young person was proved, and that had been omitted, and only in those circumstances could the information not be retained. So it's not a question of anything going wrong for the young person other than if they've already been convicted and their identifying particulars are on the record, that information will be kept. And what that will mean is that if that young person offends again, either as a young person or as an adult, that information will be available to the police, and they will be able to track the source of the offending much more quickly than they would otherwise. I can't understand why the member objects to that. I think it's very straightforward. It was an error that was made at the time. I didn't notice it. Nobody else in the House noticed it. But nobody voted on Part 3 of the policing bill in 2008. We had the debate on August the 7th and August the 28th or something, those the 27th, and what's ended up happening is that we're ending up having a debate about something that is completely, really irrelevant to the context, which is technical error requires fixing, and actually the use of urgency and retrospective legislation in order to achieve that is an entirely appropriate use of our standing orders. I support the passage of this bill.
Dr. Cam Calder.
I move the question be now put.
No, I'm